Okay, there we
Woohoo.
go.
Good
But
job, Ann.
express and document our wishes for how we want it to be when this is my new euphemism, gang, for passing on when we're going next level. I quite like it. I'm adopting. And about how to ensure that those wishes will be honored. So Althea has got incredible chops to talk to us on this subject. And I told her I didn't want to introduce her because I couldn't simplify her CV to the point where I could spit it out in less than 15 minutes. But anyway, she sent me a brief one. She is the founder of Ending Well Patient Advocacy, LLC. She's a board certified patient advocate focusing on end of life planning and counseling, aiming to help people have a good death, that thing we all so dearly wish for. She earned an executive Juris Doctor in Health Law in 2012, and she's been a professional mediator for 18 years. She's also been a hospice volunteer for 16 years, and she earned a thanatology certification in 2015, which prepares individuals to work with the terminally ill, the bereaved, and to provide death education. She earned facilitation certificates in advanced care planning from Respecting Choices. I don't know what that organization is, but we'll find out. And offers classes on advanced care planning in the community. In 2021, she became Final Exit Network surrogate consultant, where she counsels healthcare surrogates, medical POAs, powers of attorney, and hospital staff on thorny advanced directive and clinical ethics issues. So my final words were about hoping you all got the PDFs. And if you didn't, we will try again to send them out to you. So, Althea, I'm turning it over to you.
Thank you, Ann, and thank you for inviting me to do this presentation. You know, I don't care if there's 2 people or if there's 200 people. I presented to those kinds of groups too. And forgive me if you've heard a lot of this information before. You're a pretty savvy group out there in Sausalito. So you may have heard a lot of it, but some of it you may not have. So I am going to launch into my presentation and we'll see how it goes. I think I'll be able to forward, but sometimes there's an issue and I have to get out and go back in. So without further ado, hi everyone and welcome to Final Exit Network's Who Will Speak for You presentation. I'm Althea Halchuk, as you just heard, and in this role, I'm Final Exit Surrogate Consultant, and I help surrogates and healthcare proxies who may be having trouble in enforcing an advance directive. The Final Exit set this program up because they were hearing from a lot of members that their healthcare directives weren't being enforced, and they were having issues getting extra meds in a hospice situation. So really, there's a lot of reasons why this program is here. And I educate, really, a lot of my job is research and education, and I help do these presentations all over the country. And I'm helping people with, I get emails from members all the time about their advance directives. I can't really help people fill one out, but I can send them in a direction so that they can feel like they can do it themselves and really get the help they need. Final Exit's mission is they have a vision and a mission. Their mission is to educate, give people options and choice at end of life. My role is education mostly. In my program, today I'll review advance directives, offer tips on choosing an effective surrogate. The most important part of the advance directive is your choice of surrogate, and provide some guidance on ensuring your advance directives are followed. The key to having your healthcare wishes honored is choosing a surrogate who will speak for you and make sure your treatment wishes are followed. Your surrogate is so critical to the success of your planning. It's the first question in every advance directive. I've seen hundreds of advance directives from all over the country, and it's Most of the time, it's the first question. Sometimes it's a separate form where you choose a proxy or a power of attorney. It really depends on the state what the name is. So it really is that important. So who will be your surrogate? Preparation is everything. Listen to Ben, because having no plan can lead other people choosing critical care for you when you can't speak for yourself. Often you'll get treatment you may not have wanted, or you will have decisions made for you by a person you might not have chosen. Things happen, car accidents, skiing into a tree, and now you're in a coma. To quote Emily Dickinson, because I could not stop the death, he kindly stopped for me. We're all going to die, including me and everyone on this call. We need to prepare for our ending and to do it right. But advanced planning is not just for end-of-life care. A medical crisis can happen in the blink of an eye. How much worse would a car accident be if you were in a coma or an ICU with no directive and no surrogate? 5 years ago, my 49-year-old brother-in-law, Rob, had a massive stroke, no advance directive, and no chosen surrogate. His 3 brothers were blindly navigating and choosing his care, but they disagreed on what to do. And the doctor, I was in the room, and I had talked to Rob prior to his stroke about 5 wishes. I sat down with him with a 5 wishes form, and I went all through it with him, and he said, I'll do this at home. And guess what? He didn't do it at home, and he didn't have anybody to be his surrogate. It's different when 3 brothers come in a room and now they have to decide. And so the doctor just wants a consensus. That's all they want. They want the brothers to agree on what to do. And they really couldn't do that. So they err on the side of life. So they kept him alive. And that's what can happen. So you really do need to be prepared. And many of the events are survivable. He survived, but living a good quality of life and merely surviving can look very different. Don't wait until you're too sick or you're in a coma, like my brother-in-law, to choose future healthcare treatments. And these are the poster girls for failing to prepare. And every competent adult over the age of 18 can and should have an advance directive. Excuse me, you probably heard of these women. They are famous, infamous, really. Karen Ann Quinlan, Nancy Cruzan, and Terry Schiavo were in their 20s. They weren't even 30 yet when they ended up in a permanent vegetative state with no hope of recovery. Karen Quinlan mixed diet, drugs, and alcohol. Nancy Cruzan was in a car accident. She landed face down in a ditch of water. And Terry Schiavo suffered a heart attack. All 3 were artificially kept alive, in other words, in limbo, for many years because none had a written advance directive. The courts ultimately gave the 3 families the right to discontinue life, but you can see on the slide, Karen Ann was in a coma for 10 years, Nancy Cruzan, 7. In fact, Nancy Cruzan's headstone shows the date of her birth, the date that she had the car crash and was in the coma, and the date that she finally died. And then Terry Schiavo was 15 years. Well, the family fought nationally. It was a national battle, and nobody wants to be involved in somebody else's healthcare decisions. So don't let this happen to you. These women were all at the center of landmark right to die cases. I was in my 20s when I heard about Karen Ann Quinlan, and that's how I got into this work. She was on life support, and I thought, how horrible is this? She's never going to recover, and her parents just want to take her off life support, but that was not to be. So she's the reason I am on the journey that I'm on. Create an advance directive, have the conversation about your treatment wishes and goals with everyone in your family, and don't forget to include your close friends.
Oh, sorry, kids.
I think that's you.
It is. Nancy, what?
Okay. In 1914, so think about this, over 100 years ago, this New York Supreme Court judge, Benjamin Cardoza, he's very famous. He's had a lot of precedent-setting cases in New York, but other states have adopted a lot of what he said. He said, every human being of adult years and sound mind has the right to determine what shall be done with his own body. Very famous case. I read about it in law school. I briefed it. Really, every competent adult has a constitutionally protected right to have treatment or not have treatment. You can refuse medical care. So it's a fundamental right. We've heard a lot about that this week, haven't we? It's you have a fundamental right to choose or refuse your own medical care. And the basis for this is the basis of this statement is informed consent. The consent must be voluntary. You must know your choices, and the patient must have the capacity for refusal. Furthermore, the choice should be made without any undue influence from other people. This is a personal, informed decision. The Patient Self-Determination Act in 1990, the law was passed by Congress. In 1991, it became effective, and it created patient rights in advanced care planning. So an advance directive really equals a living well plus a healthcare power of attorney or surrogate. It's those really two pieces of the document that equal an advance directive. So this was codified into federal law. Thanks to Nancy Cruzan and her family, her parents went to the Supreme Court of the United States to have her taken off of life support. And they said no, because Nancy didn't have an advance directive. Her parents could speak for her. They really said that, but in this case, they could not because they didn't know what Nancy really wanted. So that shined a light on the need for advance directives. Compliance in this law is mandatory on the part of healthcare institutions. They need to communicate and protect patient rights. And advance directives give competent adult patients the right to, and I'm going to say this many times, to accept or reject medical treatment. You don't have to have it. And the right to choose a surrogate. At first, when this law went into effect, the medical staff, they just would ask a patient, do you have an advance directive, and let it go with that. They checked the box. Yes, I asked them. But Medicare found out that this was really not the spirit of the law. It might be the letter, but certainly not the spirit. So in 2016, they began paying advance planning conversations to as a part of your wellness visit. And if a patient has an advance directive, the doctor gets a hold of a copy of it, puts it in their medical record. And if they don't, the hope is somebody on the medical team will direct them in ways to complete one. And I think, Anne, you asked about respecting choices, and respecting choices, there's kind of all over the country, but it came out of a group in, I think it's Wisconsin, that really talks about the conversations around the planning. It isn't so much getting people in a room and, standing over them with a whip to get their advance directives done. It's really about letting them know these kinds of conversations exist, and they really need to think about it. Otherwise, they're going to be lost. So part of the law also requires your surrogate make healthcare decisions that are in accordance with your wishes, including your religious and moral beliefs, or they make decisions, this person, not a they, it's a he or she, whatever gender, but it's one person, it's not more than one. Make decisions that are a reflection of your values to the extent your surrogate knows about these values or could find out about them with reasonable effort. In other words, they could ask family members. Your surrogate may have a question they want to ask the eldest daughter, if she's not the surrogate, about the mother's religious beliefs and would she want this, that kind of thing. If your surrogate does not know your wishes and can't find them out easily, then the surrogate has to make the decision that's in your best interest. And I'll talk about the best interest standard in a minute. Once you lose capacity, so you can't communicate, you're probably in a coma, or you have a some kind of tube that's helping you breathe, you lose control of your decision makings. So it's important that you think about these issues ahead of time and execute a medical power of attorney and a living will. Capacity versus competency. People get these confused all the time. Nina, can you please mute your...
I thought I was muted.
No, sorry. There you go, muted, thank you. Capacity and competency are often confused and sometimes used interchangeably, but each term has a distinct meaning and intent. Capacity is a medical determination and involves a person's ability to make informed decisions and provide informed consent for a medical issue or treatment. Patients with decision-making capacity must understand the information that's being relayed to them, the risk of any kind of treatment, or non-treatment, benefits of the treatment, or benefits of not doing the treatment, and alternatives to the treatment. So they have to understand all these things. And capacity is determined at this point in time and needs to be reassessed with each major healthcare decision. So what does that mean? That means that every time somebody's in the hospital, so say they're kind of at the end of their life and this happens, they keep going into the hospital for one reason or another. They get pneumonia, they get cured, they come out, they have some other issue that most times the medical staff will assess the person to make sure they have the capacity to make these kinds of decisions. So it's at the point in time for a particular treatment. It's not across the board forever until the end of time. So you need to really remember that. Somebody can have capacity one day and not the next, and then the third day have capacity again. Competency is determined by a court. It's a legal term and involves a judicial process that determines the capacity of a person to act on his or her own behalf and have the mental capacity to participate in legal proceedings or transactions, mostly financial. And my brother-in-law, what ended up happening is one of my other brother-in-law went to court. He's got guardianship over Rob, which gave him the right to make all his financial and medical decisions. However, Rob could be reassessed by his neurologist, and his neurologist could say, you know what? He passes this criteria and he could make medical decisions on his own. And so it's, it can get kind of murky and muddy, but those are the differences. And sometimes capacity overrules competency. 4 elements of decision-making. The patient understands the provided information. They appreciate the situations and the implications of the choice. What if I do this? What if I don't do this? What are the implications of that? Their rational reasons in reaching a decision. Like they thought about it, they waited, they went through everything and said, yeah, if I do this, this will happen. If I don't do this, that'll happen. And finally, they can express or communicate a choice. They can say, yeah, doc, give me more chemo, or no, doc, I'm done. If all 4 of these are exhibited by the patient, it's determined the patient has capacity to make healthcare decisions. So in Rob's case, I believe that there are many things he understands because it's been 5, almost 6 years. And so he does understand a lot of, he knows if he doesn't take his blood pressure medication, what can happen. So just keep that in mind. Capacity is a big deal, and that's what can happen. Here's some surprising facts that honestly, I just learned. I did a webinar with some medical group, I don't know, 2 months ago, and they were talking about this. And prior to this, I thought that competency was overall. The judge said it so, but it isn't. Capacity is not all or nothing. Even people that have a mental illness or dementia can still have the capacity to make medical decisions. And I think people have a tendency to take the decision-making away from a person with dementia. But if you've been around dementia patients, Alzheimer's patients, they can have very lucid moments where they know what the heck's going on and what's happening to them. And if somebody's assessing them in that lucid period, they could have capacity to make healthcare decisions. A person who's been declared incompetent by a judge can still be determined to have decision-making capacity by a doctor. The court order does not overrule the medical determination. In most states, it's a doctor who has to make that determination, but I took an ethics course in Washington, D.C. in MedStar Hospital, and the ethics people were making that determination. People with a PhD, not an MD. So it really depends on where you are, who can make that determination about capacity. And just because you go against medical advice doesn't mean you lack capacity. You can check yourself out of the hospital and go against medical advice. You have capacity to do that if that's what you want to do. Here are the surrogate decision-making standards, and there's basically 3. Express interests are, and this is your surrogate now needs to make a decision for you because they're your surrogate. So the best one is express interest. And it's your implicit instructions in your advance directive or prior statements, conversations you've had. This is the best one. It's the most convincing evidence. If Nancy Cruzan had had an advance directive, bang, and it said no life support, no feeding tube, she would have been done. And I think in like all 3 of these cases, it was the feeding tube. Karen Quinlan was on a ventilator, but at one point they said, okay, you can disconnect the ventilator, and they did. And guess what? She breathed and she stayed alive for several more years. It was the feeding tube that was keeping her alive. So the second under express interest is if you have a conversation like she had with her buddies at work. I never want to be on a feeding tube or a ventilator. Don't do CPR on me. Let me just go. Those are express interests stated by the patient. The next standard is substituted judgment. It's an educated guess where you apply your values, beliefs, wishes, and preferences, or the patient's beliefs, values, wishes, and preferences, where the surrogate has no directive, or the directive doesn't really cover the situation, or the directive is not clear. So they're substituting their judgment, but they know you. They know really what you want. The best interest standard is an objective weighing of benefits and burdens, but it's based on what a reasonable person would want in given circumstances. The law requires a healthcare surrogate consider your medical condition and prognosis. Now, this is under the best interest standard. The dignity and uniqueness of your personhood. This is in the Patient Self-Determination Act. These are in there. The possibility of an extent of preserving your life and functioning, or improving, preserving your functioning. So making you live, making you able to function, the possibility of relieving your suffering, the balance of the benefits of the proposed treatment against the concerns and values of what a reasonable person would want in your circumstances. So it's the reasonable person standard. If your patient or person has not done 1 or 2, then the decisions that are going to be made for this person are what a reasonable person would want in the same circumstances. So as you can tell, some of these are murky, subjective, and sometimes there is no straightforward answer. Your advanced care plan should include your healthcare surrogate, number one, or power of attorney. I have a client where I'm her professional surrogate, and I have her 5 wishes form. She's named me in there as her surrogate, but a power of attorney is really stronger. And in most states, you can do more with a medical power of attorney than you can as a surrogate. In some states, you can't do like a tissue donation or have some kind of burial that is against whatever it is in the state. But a power of attorney really has more power. It should have your end of life values and beliefs, your goals, preferences, and choices, your circumstances and scenarios. So if you have Parkinson's, what is this advance directive? How is it related to your Parkinson's? Your specific medical interventions. Do you want a feeding tube? Do you want antibiotics if you're at the end of life? That's a big question because antibiotics are the standard of care. But if you're in a position where you're at the end of life, and I have a case I'll talk about sort of at the end, where antibiotics are a medical treatment. If you want them, great. If you don't want them, you need to write that in your advance directive. And your end-of-life plans and arrangements. I keep harping about 5 wishes, I know, and I'll talk about why in a minute, but it gives you a place where you can write, do you want a memorial service? Do you want an obituary? Do you want to be cremated? Do you want a casket? Whatever it is you want can go in your advance directive, and probably should. Here are the forms and advance directives are your healthcare wishes, living will, medical decisions, and your healthcare power of attorney. There's a life care packet plan, a life care planning packet, advanced healthcare directive under the California probate code section. It's free. Hello. It's free. As is Prepare, which was, I'm pretty sure that one was also developed in California. So you can get free forms, they're out there. And 30% of Americans have an advance directive, and that's up from 25% since the pandemic, when people found themselves in an ICU and nobody could visit them, even if they had a healthcare surrogate. Really, it was telemedicine at best. And so they said, you know what, I think I need to have an advance directive that, will spell out my wishes. So choosing a surrogate, somebody you trust to make decisions, to act on your behalf when you cannot speak for yourself. And part 2 is your living will, a written statement of your end of life wishes about your healthcare and medical treatment preferences. And you can spell out all those pre-planning things. I just prepaid for my cremation. I don't want my family to have to figure it out. I went to my local mortuary, signed the papers. If I die anywhere in the world, they will transport me back to this mortuary for cremation and then ship my ashes to my people in Massachusetts, because that's where I'm from, and that's likely who will be handling my remains. So really, these are decisions you need to make, and ahead of time is better for your family. It really is. It's a real gift. It's a tool. The advance directive is a tool to think through and communicate your end of life treatment on non-treatment choices. And advance directives are state specific. So you want to pick one that's legal in your state. Again, California, this would be legal in California. But I find that in California and other states, my state is a 28-page form. And I mean, I don't need legalese in an advance directive. I want it to be simple. And 5 Wishes did a form that they targeted towards 5th graders. They didn't want to make it so complicated that people couldn't figure it out. And really, if you've ever seen one, it's very simple. I included a sample in in the forms that I sent to Ann. It's a PDF and it just shows a sample. And the way you find out how you make it legal in your particular state, you go on 5wishes.org, you look up the form and it will have a drop-down menu. Is this legal in your state? And it's legal in all 50 states and the District of Columbia and Guam. So it's legal in the and some of the territories, and it will show you what you need to do to make it legal in your state. And sometimes I had a case where somebody had emailed me their particular state, and I forget where it was, like Montana or something. And yeah, 5 Wishes was legal, but they required you to download a 1-page form that was like a living will that you attach to the 5 Wishes form, and that made it legal. I don't know why they needed that, but they did. And so you do what it says to do. In some states, you need 2 witnesses. In other states, 1 witness is fine. In another state, no witnesses. You don't need any witnesses in New Mexico. But really, it's better for your surrogate if you have your advance directive signed, witnessed, sometimes even notarized. Some states require a notary, not many, but some do. So really, you need to find out what makes it legal in your state. So with 5 Wishes, you just really check a box. And my client added 4 pages to her 5 Wishes document to make it her own. People she didn't want at her bedside. People she did want at her bedside. I mean, you can go as far out as you possibly want, but me as her legal surrogate, I need to know these things. What does she want? And when does she want it? So you can make it your own form by just adding and attaching. Who can't witnesses be? Family related by blood, adoption, or marriage. Anybody that stands to benefit in your will or your estate plan. The surrogate can't be a witness. And your healthcare provider or any team member, they can't be your witness. And I've heard a lot of scuttlebutt about hospice people that, are they considered medical team? You know, as a volunteer in a hospice, a medical person? I'm a volunteer in a hospice. I don't consider myself medical. So, really just about anybody else can be. Your next door neighbor can be your witness. Advanced care planning requires many conversations. You can't just fill this thing out. You need to have candid conversations about your treatment wishes with your surrogate, your family, anybody else who might be contacted. If they get your phone and you're in a car accident, they're going to try to probably call, I don't know, your last caller, unless you do something on your phone that gives them an emergency contact. After Nancy Cruzan's parents got shot down at the Supreme Court, they tossed it back to the lower court because that's how it's done. And the lower court accepted testimony from her friends that she worked with. So this is how important the conversations are. She didn't have anything in writing. All she had was a conversation with her workmates that she'd never want to live like a vegetable, be hooked up to life support. And guess what? That's what happened to her. So until these people were allowed to testify, after the court heard that testimony, they took her off of life support. That's how important the conversations are. I think they're almost as important, if not more so, than who you pick as a surrogate and who you have these conversations with. Think of the advance directive as your roadmap and conversations with your surrogate as the directions on the map. People assume others are on the same wavelength. I hear it all the time. Oh, my family knows what I want. No, they don't know what you want unless you told them. So it's all about expectations. You need to spell out your needs, your wishes, and how you expect your surrogate to answer and carry out all of these wishes and end-of-life goals. So I've been harping on about a surrogate for the last, I don't know, 20 minutes, half hour. And what is it? And who do you choose? A surrogate is a substitute healthcare decision maker It's the person who speaks for the patient who lacks decision-making capacity. We had a whole discussion about capacity. They implement your advance directive and consent to and refuse some or all medical treatments. You need to choose a person carefully. It may not be, the best person may not be your spouse or your child or even your best friend. And it's not just medical treatments either. I mean, if a person reaches the end of life, your surrogate decides whether or not to put them on hospice if they don't have capacity, if they qualify, or into a nursing home if they've been living in their own home and now they're incapacitated. Can they stay there by themselves? Do you hire help to come in? So really, the surrogate has the control of all of your medical decisions when you can't make them yourself. And your advance directive is a guide, but they have a certain amount of autonomy when they're making these decisions. So they're also known, in Massachusetts, my aunt's surrogates, I was called a proxy there. That's different. It's a different name, but it's the same job. It's the same role. Durable medical power of attorney, healthcare agent, proxy, surrogate. They're all the same thing. They're an authorized decision maker. And regardless of the terminology, it's the individual who is recognized to make decisions on behalf of the incapacitated patient and recognized by medical facilities, healthcare facilities, long-term care facilities, all of the above. 6 traits to look for when choosing an effective surrogate. And this is also in your packet. I think I may have more than 6 in the PDF I gave you. Here's what you want to look for. You want a person who's comfortable making decisions on your behalf, even if your wishes differ from theirs. This is about you, not about your surrogate. If you want something at end of life that they disagree with, and they're not going to carry it out because they disagree with it, you don't really want that person as your surrogate. You want somebody to step up and say, yeah, I don't agree. I wouldn't do that if it were me, but I will follow through on your wishes. You need someone with the emotional strength to carry out choices at the end of life. Some people might feel guilty or second guess themselves, or family members might second guess them. What do you mean you're not putting in a feeding tube? Can they put these feelings aside of feeling guilt and do what's best for you? You need to find out ahead of time. Someone who will stand up for your wishes and won't be intimidated, bullied, or guilted into something. This is how the surrogate program got developed. People were telling Final Exit, you know what? I heard about one hospice patient who they did everything they could for her. There were no more treatments. She was going into hospice. She wanted to go home, and her oncologist refused to let her go until he put in one of those PICC lines that would give her some kind of feeding tube. And she said, no, I don't want that. I'm going home to die. I don't want a feeding tube. And so it had to go to an ethics committee. That's not right, because ethics committees take time. She lost valuable time at the end of her life because this doctor was imposing his values on her. So that's why I'm here. I could have told her by phone, by Zoom, that's it. You know, you have the right to make these decisions and no one else does. So you don't want a person who cave to medical, if a medical request goes against the advance directive or the treatment, and you want someone who's going to challenge it. Like I would challenge that feeding tube in that patient if she didn't have capacity. No, she didn't want that. You want a person who isn't afraid to speak up or ask questions or ask for help. A surrogate isn't expected to know everything. I have a health law degree, but I'm not a medical person. I couldn't do, my daughter is an RN and she does some of the, you know what RNs do in the trench. I couldn't ever do that. I'm not a medical person, but I've been around enough ICUs and emergency rooms to know what's right and what's not right as far as the patient's rights are concerned. Experts are there to help the surrogate. If they don't understand a treatment, they'll lay it all out And you should not be afraid to seek help from others. If you feel ignored, if they're trying to overrule you, if there's 10 doctors in a room and it's just you and they're like, you need to do this. No, you don't need to do this. You can stop right there and say, no, I need to talk to the ethics committee. I want an ethics consult, or I want to talk to the legal or compliance department. Typically lawyers in hospitals, even though they're there to protect the hospital, that's why you want to talk to them, because if they're going against what you want or your patient wants, that's not right. They're breaking the law. So, and you want a person, and of course you can call me. I'm available to final exit members. It's one of the benefits. You can call me. I'm available 24/7. Of course, I'm not going to answer the phone at 3 a.m, but you could leave a message and I will call you back the next morning and try to get it figured out and get what you need. You want a person who's going to remain calm in a crisis. You want the person who's going to be in the lifeboat, that isn't going to be going all wild and crazy and screaming and crying. You want a calm person, because things change on a dime. Emergent situations, 1 minute it's one thing, the next minute the blood pressure's down on the floor, and what do? You want that person. And most important is you want a person who's willing to be your surrogate, ready, willing, and able to serve at a moment's notice. And sometimes it can be that way. A person who understands your wishes and will enforce them. How do you ask the person? It's a big responsibility. You pick a quiet time and a place and say, you know what, I have a favor to ask. I hope you never have to do it. You ask them, you tell them what a healthcare agent does or a surrogate does, what their responsibilities are. You ask them if they have one. I don't know that I'd feel comfortable picking a surrogate who didn't have an advance directive themselves. So you probably want to know that early on. And you explain how you want the decisions to be made and what you expect of them. There's only one brother missing here. This reminds me of my 3 brother-in-laws and the 4th brother-in-law in the bed. I mean, really, one is saying, we want him on life support. I want him on life support. Keep him for as long as he can live. And the other one's saying, we shouldn't let him linger. He's gone, let him go. I had this, there was a case a couple of months ago, a young woman, she was in her 20s. She was still in college. Her father didn't have an advance directive, or he had not really named her a surrogate, but she was the oldest child. He was divorced, so his wife couldn't be his surrogate. And he had been in the ICU in the COVID ward for 2 weeks, wasn't expected to recover. And they wanted to remove him from life support. And his daughter wanted to. She said, I talked to my father about this. We had discussions about it. He wouldn't want to live like this. But his siblings were screaming and yelling. And sometimes it's the squeaky wheel that gets the grease. So they had to have a discussion about it. And they listened to her, because in Arizona, there's a hierarchy, and she was at the top of the list as his eldest daughter. And she and her sister decided, they had a conversation about it, and they took him off life support. And these siblings made their life miserable, tried to guilt them. They did everything I talked about, bullied them. I mean, really, this is what their dad wanted. And so this is why you need an advance directive, because this will show them, no, I never wanted this. If I'm in this position, no. Most conflict in the hospital is in an ICU among family members. It's not usually doctors fighting with each other, although sometimes you can have that. It's family members. And another common scenario, very common, is far away relatives who have not seen the patient in years, who swoop in to tell, and that's the term, they swoop in to tell everybody what they think should be done. What happens if I don't choose? The perils of not choosing. When you have a choice, you have to make a choice and you don't make it, that in and of itself is a choice, because someone is gonna make the decision for you. It might be somebody you would never want, like your least favorite sibling, but they just happen to be higher up in the pecking order. or your eldest child who's irresponsible or worse. I've talked to a lot of people who it's not their eldest child that they get. It's somebody that is more responsible, that can make decisions. So really, that's why I say it isn't always your spouse or a particular child or your friend. You need to be deliberate about who you pick. This is a hierarchy. This is Arizona's, but it's pretty typical in most states. This is the order that it goes in. This guy that I just talked about, his ex-wife is the friend of mine, and really she couldn't decide. So adult children, that was her, she stepped in. So often though, what happens, and this is sad, is that the medical team will turn around and talk to the biggest mouth in the room. Somebody comes in, oh, we should do this, we should do that, we should do this. And the surrogate, if they are not strong enough, don't have the power of attorney with them or the advance directive, the medical team's going to listen to that person. The one, like I said, squeaky wheel gets the grease. They're just looking for a consensus, like my brother-in-law. That isn't what he wanted. He definitely didn't want what they did to him. What's California's method? That is that consent form I sent to Ann that everybody's having a problem opening. I can send you a link to it, which it should get you right into it. All the other PDFs open, just, if you're having trouble with a zip, that often happens. That's why I send them individually rather than a zip. And I know there's a lot of resources there. So anyway, California, they have a rule on determining who can speak for an incapacitated patient when they don't have a directive or a surrogate named, a power of attorney. This is when you don't have anybody. If a person lacks capacity to make decisions, the physician and healthcare team usually turns to the most appropriate decision maker among the patient's family or friends. Well, who are they to decide? They just met you. The family just came in from Oshkosh and they don't know the family. They don't even know the patient, and they're making a decision on the appropriate decision maker. Hopefully the family's close and they all can agree on the treatment, but a lot of times that doesn't happen. And so they're picking, they're hoping the person has a close personal relationship with the patient and knows everything they want, has had conversations, but that doesn't always happen. So the process is in California, it's on a form, but it's not in a statute. In Arizona, it's a law. This is who gets to decide. And it's so clean and so clear cut. I think it kind of makes it better. What happens if your surrogate is on vacation or away on business? No, will not. How about if they're backpacking in Big Sur and they don't have internet? Their phone doesn't work. No longer willing to act as your agent. Deceased, otherwise unavailable during a crisis. You need to plan ahead, need to pick an alternate, not a committee, not a group of 5 or even 2. You want one person to make the decision, a primary, and then a secondary. So if they can't reach the person A, they can reach the person B. And that's why you don't want to. Another PDF I sent, why 2 heads are not better than 1. Hospital staff does not want to have to track down 2 surrogates if both are named. It just makes it messy. And really, you're going to get the best care if you have one decision maker. Not to say that the primary and secondary aren't on the same page and talk to each other and are there for each other, supporting each other. It's a hard decision sometimes, pulling your parent off life support. So really, it's always better to have somebody in the wings that can help make these decisions. Here are some things you want to think about. Creating an advance directive isn't all that complicated. It's really, you're just stating your wishes based on some future events, some hypothetical. But your wishes can change, and sometimes based on life experiences or circumstances or a diagnosis. You can revoke a surrogate and appoint a new one at any time. So you appointed your sister, and now she has advanced Alzheimer's, or even not even advanced. She has mild dementia. Do you really want her making your healthcare decisions down the road? Probably not. Although we just heard she could have capacity to do that. But you know what I mean, that if this, you can always change your surrogate. Wishes may change due to remarriage, health, or a new cure. All of a sudden, those oncologists came out with a cure. God bless America. There is now a cancer cure that actually cures people. You could change your advance directive. Okay, I want to be kept alive under these circumstances. They have this new drug. I'm going to try that. If it works for 6 months, great. If it doesn't, you know what I mean. You can consider using a lawyer if it's complicated, but you don't need a lawyer for this. You can do this yourself. A lot of times when you're doing your estate plan, my husband and I went and did a trust in our estate and all of that. And she did an advanced care directive, and I ripped it up as soon as we left the office because it was too complicated. It really, and it didn't say a lot. It was that Arizona 28-page form. No, thank you. Mine is 5 wishes. Nobody's paying me to say this. I give 5 wishes forms away all the time, and I have to buy them. Like, they're not giving me free forms to pass out. You can revoke your advance directive orally by telling your healthcare provider you no longer either want that or any parts of it. So you can make an oral declaration, say you're in the hospital, and say, oh, you know what? I know I said I want a DNR, but you know what? Give me CPR. You know, if I'm just, I want CPR now. You can always change it, but you can't have cross-outs. Whoops. You can't have cross-outs where you cross out somebody's name and put somebody else's name as the surrogate. Anytime you make a change, you have to redo the advance directive, gather the copies you've handed out, get rid of those, make new copies, and give them to all the people that you gave the first one to. And copies are fine. Somebody asked me that in a presentation. Yes, absolutely. You don't need the original advance directive. What you need is a copy of the original advance directive. So just keep that in mind. You can keep a copy with you. Some people keep it on their refrigerator, although there's a story with that too. Finally, consider making a video. Videoing this in this day and age is, you could do it on your smartphone, 5 minutes about what you want, what you don't want, and keep it on a thumb drive, keep it with your advance directive. And it's not your advance directive, it's what you want, and it's backup for your surrogate who's going to try to enforce your healthcare wishes. And so it can be reassuring, not only for the surrogate, but for the family to hear from the horse's mouth, no, I don't want a feeding tube under any circumstances. So the swooper who comes in and says, oh yeah, we want a feeding tube for her. No, here's the video of her saying she would never want that under any circumstances. So there's a couple of companies out there that will video your advance directives for you, but really it's, you don't want to make this too complicated. You just don't. So when do you review your advance directives? They call these the 6 Ds because it's catchy. You can review them every year on your birthday or Healthcare Decisions Day, which is always April 16th. We had an off year because of the pandemic, but it's always April 16th. It has been for many years. And it's death and taxes. Taxes are April 15th. Healthcare Decisions Day is April 16th. And review. If you don't have any changes, write a date at the top with your initials that you've reviewed it and it still holds. Everything still holds. Here's when you want to do it because things might have changed. Every decade, minimum of 10 years. Like if you haven't looked at it in 10 years, drag it out, look at it, see if everything's copacetic. If you're in your 70s, you probably want to do it more than every 10 years. But if you're young and healthy and you did this at age 35, you probably don't have to look at it for another 10 years. The other D is the death of your surrogate or a loved one might cause you to review and make changes to your advance directive. Divorce, like I said, your ex can't be your surrogate. There's always going to be an exception to the rule. Sometimes they can, but you need to check that out in your particular state. California, I don't know. Diagnosis change. You seemed healthy one day and then you get a cancer diagnosis the next. Suddenly your future scenario is here. How are you making decisions based on having a cancer diagnosis? You decline in health. Are you having a lot more health issues? Like you were independent and going to bingo and traveling all over the world, and now you can't really seem to leave the house much. Maybe it's time to take a look at your advance directive. And domicile changes or distance of the surrogate. I've heard them both under D, so that would make 7 Ds. You move into a facility, or you move in with your daughter or son, or your surrogate moves. Like I said, my 2 aunts were Mass, so yeah, I know it can be done. And the person who's my client, her professional surrogate, she lives in another state, probably about 6, 7, maybe 1,000 miles away. She's perfectly comfortable with me being here and her being there. And she knows I will drop everything if she needs me. I'll be at her bedside when I need to be. So you need to make sure if your surrogate is someplace far away, then that they will drop everything and come help you. But with telemedicine now, I mean, you're on a tablet in the ICU and you're 2,000 miles away. So really, I think distance isn't so much a big deal anymore. Why do so many advance directives fail? Lack of communication is the #1 reason. They can't find a copy. You never gave it to your doctor. You never told your family you did it. Where is it? You need to tell your family that you did it, where it is. Give them a copy if there's somebody in your family you think should have one, and never, under any circumstances, put it in your safe deposit box. Because by the time they get that box open, if you're incapacitated, the crisis, it's too late. It's just too late. Another reason, the surrogate didn't know they were chosen. My friend Helen Bauer does The Heart of Hospice. It's a podcast. And she said she had a surprise surrogacy one day. She's driving and an ICU calls and said, what do we do with this incapacitated patient named Helen, who named Helen as a surrogate? And Helen said, I barely know this person. Helen was a hospice nurse. And she said, I don't know what this person wants. And she said she muddled through the woman was incapacitated, never came out of it. And Helen had to plan her funeral, had to put her in hospice, had to move her to a facility. She had to do all those things without even knowing she was the surrogate. She was some random family member that showed up at events, and she knew Helen was a hospice nurse, but she never asked her. So you want to ask your surrogate if they want the job. The surrogate is unavailable. Again, they're backpacking somewhere in Big Sur and they can't be found. They're on a world cruise. So that's one reason advance directives fail. They're not qualified. You pick somebody and they don't have a clue. They refuse to follow the directive. While it might have seemed like a good idea to be your father's surrogate, when it comes time to shut off his ventilator, that's push comes to shove. And you don't have to do it, but you've agreed to do it. And so that's why an advance directive might fail. Family members disagree. That's another big reason. Again, I'll never forget my brother-in-law's in the room fighting about what the other brother-in-law in the bed wanted. And the one who they listened to had no clue, never even talked to him about it. Well, the other 3 people in the room had, but they went with life because that's how they do it. The surrogate's understanding of what the advance directive says differs from what the patient meant. So avoid vague, subjective, boilerplate terms like extraordinary efforts, heroic measures. What does that mean? I mean, pacemakers were extraordinary in their day, but they're difficult to turn off, really awful. If you want to turn one off, and I could spend a whole half hour on that. Once they go in, they're hard to take out or shut off. Quality of life, what does that mean to you? You need to say, okay, if I have to go to a nursing home, if I can't toilet myself, the line in the sand is different for everyone. You need to spell it out. And finally, no hope of recovery. It's so vague. It leaves the door open for a doctor to give whatever treatments, more chemo. There's always hope, there's miracles. And so they'll feel free to give additional unwanted, even futile treatment if you haven't spelled out what no hope of recovery means. Medical, whoa, I don't know what happened, but I'll get there. This happened before, hold on. Sorry. And I'm almost done, I promise. It's not, for some reason. Nope. I'm just going to go with this slide. So look on the left. Medical providers can refuse to honor your treatment wishes. They don't have to do what you want. If they have a conscientious objection, or it's against their facility's policies, maybe they're not qualified to do what you want. They can refuse, but they have to tell you they're refusing. They don't really even have to tell you why. They just say, I'm not going to do that. And they have to help you transfer to somebody who will help you. Sometimes that's easier said than done. Strategies to use when you get pushback from medical staff. Advance directives are legal documents, and doctors have a duty to respect your wishes, listen to your surrogate's directions. It's their duty. It's the law. If a healthcare provider acts against a directive, they can be found guilty and criminally and civilly and required to pay damages. So the best strategy, you're in that situation, they don't want to follow what you have to say. You look at them and you say, you're doing this treatment without my consent, and I want my lack of consent put into the patient's medical record. It's important to leave a paper trail. So insist their denial be put in the medical record. They're going to hate that. So the other thing you want to do is you want to carry your healthcare power of attorney and advance directive with you to prove your authority. You don't rely on the hospital to have it. There's a lot of issues around advance directives in hospital settings. Here is failure to follow advance directives or the surrogate. And these are cases, and you'll notice that really from 2016 on, these cases, that's the date. So these are relatively new because it takes 3 or 4 years to get a med mal case through the courts. So in case number 1, Alicia versus the Doctors Hospital of Augusta, it was a grandmother. Alicia was the surrogate. She was a young girl. Her grandmother had an advance directive. She didn't want CPR, and they gave her CPR and they brought her back to life. She didn't want it. So not only did they ignore the advance directive, they ignored the surrogate. A judge in the case said it is the will of the patient or the designated agent and not the will of the healthcare provider that controls. And for so many years, it was the will of the healthcare provider. I mean, sad. I'm sure you could all tell me stories about how some doctor went against a patient's wishes. The plaintiff, when they accepted the $1 million settlement, the plaintiff's attorney said he wanted to shout it from the rooftops because this is a new trend in these kinds of cases. You can't keep somebody alive and then just say, oops, they're alive, not, you know, and leave it to the family to pick up the pieces, because that's what happens. Magny, number 2, is a California case, and social services took away the surrogate's right to make decisions for the patient. They settled for $1 million again, and there are 2 providers in the social services, they're county officials, that are going to be prosecuted if they haven't already in this case. O'Donnell was one of the first jury settlements. They gave the family $409,000 for keeping the patient alive against their wishes. Bone is it's in Alaska. That one just came out at the end of last year. And what's been happening, what happens typically is the hospital or the providers get sued. It goes to some court somewhere and they throw it out automatically. They always have. Because typically the provider was told they had immunity because they could do anything they wanted and they had immunity. But guess what? They don't. In the Alaska case, it went to the Alaska Supreme Court and they reversed the lower court's decision to dismiss, which means it goes back to court to be reheard. Faith alone does not provide immunity for failure to comply with a healthcare surrogate's instructions. So this doctor thought he was doing it in good faith. Well, sorry, you need to listen to the people who have the authority to make the decisions and not your good faith. Greenberg is a case in New York that is so despicable. He was a dentist and his wife is a doctor, and they had their advance directive all spelled out, a dementia case. He didn't want to live. He didn't want antibiotics. He knew that would extend his life. And what does the doctor do? Gives him antibiotics, drags him back into life. This was a guy who was so vital and so alive and then had Alzheimer's. He was in the fetal position. He had been like that for years. And these people gave him antibiotics and kept him alive for, I don't even know how long, another year, another 2 years, whatever it was. So the wife sued. And I mean, that just happened recently. So guess what? You're going to hear a settlement in that case. And I'll tell you all about it because this has become my new passion. Because I'm in this line of work, doctors need to listen to patients. That's the bottom line. They have an advance directive. They have a legal surrogate. They need to listen. But again, surrogates can be challenged too. A patient signed an advance directive, but the surrogate refused to remove the life support. There you go. The patient said, I'm at this point, take me off the ventilator. And the surrogate said, no. The hospital sued the surrogate and won, but by then the patient had died, so it was all moot. The takeaways from today, I've been going on and on about them. Number 1, create an advance directive, choose an effective and reliable surrogate, video your wishes, have the conversation with everybody you can, update as needed and keep accessible, and give the copies to your surrogate, your healthcare provider, and your family. Advance directives are not one and done. You need to review them, update them regularly, make any needed changes, or just sign that there are no changes. Little initial at the top. Keep it updated and easily accessible to ensure your wishes are honored. One thing about, I used to say, keep it in your glove box, but I don't say that anymore because I did a presentation and sure enough, an EMT came up to me after and said, you know what? They can keep it in there, but we're not going to read it. We don't have time to read and interpret because advanced directives need interpretation. So I think the best thing to do is you can put an emergency contact on your smartphone. And I did this, I have an Android, I'm sure Apple has the same thing, where somebody turns on your phone and you know how you have to scroll up and put in a password. This is before the password. It says emergency contacts. I have 2, my 2 surrogates. If they can't reach one, they can reach the other. And that's what an EMT will look for. They'll look for an emergency contact something in your wallet that says, here's my surrogate, here's their contact information. You want to keep that updated at all times so that they have a good number if they need to call it. So thank you for your attention. If FEN offers a trial membership where they send, you can try it out for a year. You can take it for a test drive. They have 4 quarterly magazines. They're so jam-packed full of great articles. The one I included as a link was my introduction when they introduced the program. So you can get 4. You just send an email to this info@finalexitnetwork.org, say you were here and you want the 4 complimentary magazines, and they'll take it from there. My contact information, FEN's vision that any competent patient unbearably suffering an intractable medical condition has the option to die legally and peacefully. Medical aid in dying is great where it is. In California, you're so lucky. But Arizona, I doubt very much if we're ever going to have it. I have a MS patient in New Mexico who can't seem to get in for medical aid in dying, and she's really in bad shape, but they won't enter her into hospice. And until they do that, she can't apply. So FEN has a program. I'm on the other side of that. You can go on their website and you can check it out. Make a connection, all the usual suspects, the website, LinkedIn, Good Death Society blog. I've written a lot of blogs in there, some of which are included in your resources. Always very interesting. Not everybody's on the same page about all this stuff. And so you can write, in the forum, you can write comments. And we have a Facebook group. Here are the resources. There's no autopilot for advanced directives, tips on choosing an effective surrogate. 2 heads are not always better than 1, believe me. The Winter Magazine, 5 Wishes sample, and the California consent requirements. And I'll send Ann a link so you can get that. One last thing, FEN's supplemental advanced directive for dementia. A lot of organizations have this now. And what it is, it's based on voluntarily stopping and eating and drinking. So you reach a point in your Alzheimer's disease, and I've been there with many, many people who have reached the end point. They don't know anybody. They don't really eat much. They almost have to be force fed. And you say between you and your surrogate where that point is, and then you can voluntarily stop eating and drinking. That's another whole lecture. It's available free at FEN's website. And it's kind of a cool thing to look at, just so that you're aware of it. And FEN members who use it get free pro bono legal support to enforce their directives. So we have lawyers that will step in if, say, a nursing home says, no, you're not doing VSED here, for whatever reason. Or a family member may object to it when it's in the advanced directive. So we have a lawyer or several lawyers that will step up. You cannot copy this. And I think that's about it. I don't even know if we have time for questions. My goodness. Ann.
If you are willing to give us some time,
absolutely.
People can leave.
We started late.
But if you're willing to do questions, sorry.
My camera was askew.
We would be most grateful to have questions from you, for you, and from our audience. And we had a couple of people who came in late. I have lots of questions. Can I start with one, please?
Sure. Yeah.
I need you to clarify for me, and I feel like an idiot here, but when somebody executes a durable power of attorney for health care, that's a legal document. So
it is.
How does that equate with appointing a surrogate, and how does the appointment of a surrogate become legally binding? Or does it?
Well, it does. The trick in that is if you have, say, a 5 wishes form, there's a spot on there to pick a surrogate. You could also have a medical durable power of attorney. And the trick is you appoint the same person. I say the POA has more power and is better for your surrogate to have. But if you don't have that, then the surrogate advance directive is also a legal document, and that advance directive has been appointed by the patient. So
Right.
really, you could have both, and many people do, because sometimes, again, their lawyer has helped them fill out an advance directive where they've named a surrogate, but then also has done a medical power of attorney. So it is a little confusing, and don't feel like an idiot, because I had this whole conversation with a woman that all she does is advance directives. And she said, oh no, the surrogate named in the advance directive is the legal. No, they're both legal, and the medical power of attorney, because you're giving a person the right to make your medical decisions. And the advance directive, again, is just like a roadmap. This is what I want. So really.
Okay. So I just want to second Althea's enthusiasm for 5 wishes. And I'm not sure what's required even in the state of California, and I have one and I can't remember whether it needs to be notarized or whatever, but it's a wonderful, wonderful document. And I highly recommend it to everybody who's trying to do this. And it's so user friendly, it won't freak you out. It's like, it really gives you the opportunity to talk on a personal level about what your hopes are for what was my new euphemism? It was next level, going next level. Anyway, okay, that's all I have to ask at this time. Let me give other people a chance. Anybody
Well, you
wants to ask
emailed me.
Yeah.
I think there's
Emailed me a
some, I think we have some things in the chat.
We
have some
do have
questions
something in the
in the
chat. Yeah.
Uh,
Should we go
But
there?
you emailed me a question.
Yes.
Um,
About travel. It was about something that
Yes.
happened to a
And
gentleman.
should you carry your advance directive with you? And I think the circumstances, without knowing, somebody fell when they got off a plane and ended up in life support
Right.
with us from the sound of it. Did they not have an advance directive? Did they have a surrogate that could make the decisions? Because it sounds like it was kind of a mess in the ICU.
Well, wherever they were, whatever instructions there were not accessible. So I was wondering about,
Okay.
I mean, if people were going to be really careful, if we're of a certain age and we're taking off on a 3-week trip to, wherever,
Right.
maybe a thumb drive with
Yeah.
both the advanced directive and possibly a recording, an actual
Yes.
video.
Yeah.
Would
But
be really smart.
one thing you can keep in mind, that in the digital age, you can have it on my directives, where you just give them the
Yeah.
it's in digital form. And 5 wishes also, mine is digitally done at 5 wishes. So how somebody accesses it is another story. Arizona just had they just changed to an online directory, and they'll take any and all advanced directives as long as they're legal. And I talked to the woman this week, and so it is. So that may be the way to go if you're traveling a lot, is to find one of those groups like My Directives or Mind Your Loved One or 5 Wishes, and have it digitalized.
Yeah.
I mean, or have a copy of it, carry it with you. 5 Wishes is like, what, 6 pages long?
Right.
And it has everything in there that you need to hand to a medical person. Okay, I'm the surrogate. Here's my name. Here's my proof. Here's the advance directive. This is what he wants. This is what he doesn't want. So I carry mine with me. I mean, because you're right. You never know.
Well, I think most of us who are here today are of feeling fragile enough at our stage of life. So we really need to start being careful about such things. I just want to tout this thing. It's called the Life File Checklist. You can't see it very well. It's not showing up. It came on one of the wonderful PDFs that Althea sent, and I can't remember which one. I have this book that I found on Amazon, somebody recommended, called I'm Dead, Now What?
I have that book.
You have it. I dearly love it. It made me laugh so hard. But as far as I know, it's not digitized, and this covers most of the same territory and seems to
Yep.
be you can fill this out digitally. It covers everything that you need to let your heirs and executors know about how you want things to be. Um, so I'm just saying that. Okay, now I'll shut
Okay,
up.
can I just like go through the questions, because I
Yes,
think
please. Yes.
Nina asked, is a surrogate the same as an advocate? A surrogate is an advocate, but an advocate isn't necessarily always a surrogate, because a surrogate is a legal designation of a person who advocates for the patient. I consider myself an advocate for my patient at all times, whether I'm a hospice volunteer or whether I'm a professional surrogate. I mean, I'm advocating for the person who's in the bed. Does that answer your question, Nina? You can nod. Okay, great. The next, can they refuse directions on a pulse? I didn't talk about pulse, but pulse are medical orders from a physician signed by either the surrogate or the patient. No, they can't. I had a client whose husband was in a nursing home, and she had signed his pulse with the doctor, and the doctor who signed it was going against it. So no, we got the lawyer involved. She sent a certified letter. No, you need to not do this, that, or whatever they were doing, she didn't like. But a pulse is almost stronger because it really deals with end of life issues, and it's a prescription. It goes wherever the patient goes. So that's, if you have a pulse, you want to keep that. They put it on bright neon paper on your refrigerator. And if you have a pulse that says DNR on it, the EMTs will listen to that. They won't necessarily, if an EMT comes to your house and you have DNR on your advance directive, they won't necessarily look at your advance directive. I said that they don't have time to look at it and interpret it. But a pulse, they have to listen to. They're legally bound to read your pulse and see what you want. It's short anyway. It's like a page. See what you want, what you don't want. So they can't refuse. The long answer to that is no, they cannot refuse. How do you get a professional surrogate? What are the advantages? Well, there's so many solo agers in this country, not just here, a lot in Arizona, because a lot of people come here and retire, and then they lose a spouse or they don't have a lot of friends. And so they need somebody to make medical decisions for them. And it's almost like, you know, I'm paid to make medical decisions for a person, basically. And there was a whole process I went through with the client that I have. I'm developing a class for Final Exit to train end-of-life doulas on being professional surrogates. If you can't find anybody to make medical decisions, that's the hardest part of an advance directive. It's who do you pick? So how do you find one? There was somebody in California that was looking for one, and I think they Googled it. I know a few in California that's what they do. If you Google it, you may find someone. A lot of patient advocates also act as professional surrogates. So you can look, you know, Google patient advocates in California and professional surrogates. Mary Kay.
I'm sorry, I can't figure out how to send the chat, but I'm wondering if this is one of the areas, am I correct in my understanding that this is one of the areas that death doulas can help you with?
Yes. We are training, the course isn't done yet, I'm half done writing it. We are training end-of-life doulas because they're already at the bedside of a dying person. They've seen it, they know what it looks like. And so, yes, they absolutely could help you do
Yeah,
that.
it seems
Now,
like they work with all aspects.
yes. Yeah. In fact, she's like a final exit client with MS in New Mexico. She has an end-of-life doula as her surrogate, professional surrogate. This woman charges her by the hour. So far hasn't needed to do anything, but at the end she will.
Thank you.
Questions? Oh, wait a minute. I'm saying a post is a physician's order for life-sustaining treatment. That's what a post is in California. They usually write it on neon paper, so it jumps out at whoever's looking for it. It's in the medical chart that way. If a person is in an ICU in a bed in a hospital, a post will be right there at the end of the bed or over the bed behind, above their pillow, because this is like the end of life wishes of a person. You don't get a post unless you really think the person's gonna die within a year. That's usually the criteria that they use. And so if that's the case, if this happens, this happens. If that, and really there aren't that many questions. It's all end of life issues. Do you want dialysis? Do you want a feeding tube? Do you want a DNR? All of those kinds of things. Lisa, your hand's up. I don't know.
Yeah, I was just gonna say, wouldn't a pulse also be really highly recommended for anybody who may have some underlying chronic condition that would require the paramedics to come out? And the reason I ask is my nephew went to EMT, and he was really concerned with my parents because he said, if something ever happened to grandma, those paramedics can just run into your house, crack your ribs, do the, everything else.
Yeah.
If you don't have a pulse. And even if you're not a year out from where you think you might be saying goodbye to everybody, if you know that you never want to have your heart resuscitated, I would still recommend getting a pulse.
I agree.
Yeah.
A lot of people that have ALS, MS, they're a chronic condition and they can live for years like that. And the woman in New Mexico, she didn't have an advance directive. She had nothing. And I keep saying, here's a pulse. This is what you need to talk to your doctor about. It's more important than the advance directive in her case, because that's just what would happen. The EMTs would come in and they'd give her CPR, and she's fragile to begin with. And so, yeah, I agree. If you think you need it. And palliative care is very underutilized in this country, and those are the people that would probably recommend it.
So is it accurate that EMTs, if they come in, if you call 911, the first place they look is your refrigerator? Is that you?
Pretty much.
Okay.
Yep.
So there are wonderful little envelope things that have a magnet on them, and you can put them on your refrigerator and put your post in there. And it's a very good idea. A good idea.
One of my aunts was she was in independent living, actually, and she was like 95. And she had a post on her refrigerator. It was, neon pink. And she didn't want CPR. She had colon cancer, and she knew, but if she didn't have that there and somebody called 911, because she was in a facility, one of her aides could have come in and said, oh, we need to have 911. But she had that post, front and center where everybody could see it, and they have to follow it. I mean, that's the law. So. Yes, Mary Kay.
I just want to confirm, when I was working as a hospice nurse,
Mm-hmm.
all of our hospice patients were given the pulse and to be kept on the refrigerator. So
That makes sense.
that makes total sense. Yeah, exactly.
I mean, 6 months, they're already at that point. And a lot of times, I've been a volunteer for 18 years, and a lot of times families get so upset, they call 911.
Yeah.
because somebody can't breathe or there's some issue. And even though they've been told by hospice not to, they do. And so you don't want somebody coming in giving somebody CPR. It's
Yeah,
really,
you've got that on the refrigerator to protect yourself.
So
yes, exactly.
where do we get a pulse? I mean, I have one, but if
Your
somebody
doctor.
were to get it, I don't know what to tell them. Where do you get it?
Your doctor needs to fill it out with you.
Okay.
And it can be pretty much any, if you had it like a neurologist and while you still had capacity, that doctor could do it. Some states, they allow physician's assistants to sign it. Some states don't. I don't know what California is. But you definitely sign by your doctor and the patient or the patient's surrogate. There's only 2 people that need to be on that document.
I want to ask people, can I be heard? I think I unmuted. How many of you were actually able to receive and open the 5 PDFs that Althea sent us? Most people, seems like. Nina, you couldn't do it.
No, but that's because I tried it before I downloaded it. Then I
Okay.
downloaded it. I'm going to try it from the desktop.
Okay, try again. It was an Adobe file, and I think it was pretty standard and should have been openable. The other thing, this one, the medical treatment of adults consent requirements, we'll see if we can get that in a form where we can attach it to an email and send it out to everybody. But the 5 things that we actually were able to send, Althea, thank you so much for those, because boy, they are solid gold, the information in those. Really.
I have a question for Althea.
Who's that?
You said Marilyn speaking. You
Hi,
indicated that, we
You're the
could go
Golden Gate Bridge.
the Golden Gate Bridge, that's right. We could go to info@finalexitnetwork.org, and we had to put in that we attended the seminar, and they were
Yep.
V2V or something like that. What was
Well, it's Village to Village Sausalito
Okay.
in today's date.
Okay, and today's date, okay.
I can't even find it on my desktop, so I'm a loser.
No,
You know,
not
Annie,
maybe not. We'll
Annie,
figure it out.
we can maybe send the documents. If anybody
We can
needs
send
them,
an
just
email
let Annie.
text.
Well, we can send them in separate documents, because in a folder, sometimes it automatically zips, and depending on your system, it may not allow it to unzip right away. So we can let us know, and we can resend that to you.
Yeah, please do, because it's really frustrating. It just disappeared.
So kids,
Okay.
I think we ought to let Althea go.
Thank you.
Thank you.
Thank you
My
all.
pleasure, though, really.
Thank you all
This
for
is my
coming.
passion. I love doing this. and
Clearly.
I hope you learned something, and I hope it wasn't too technical.
Thank you very, very much.
And
Okay.
check out FEN, Final Exit Network, guys. It really is quite the court of last resort for help. If you, well,
Althea, will we get the slides? We can share the slides, or those proprietary?
Those are proprietary.
Okay,
No,
no problem. Thank
Well,
you, though.
I try not to.
Can we get the
pass it around.
last, like 3 or 4 pages where you have all the reference
Yes, I'll
information?
send
That
you
would be helpful.
those. Yep.
we did record this, and then we're going to figure out how to make the recording available to anybody who wants to watch it again.
Thank you. Thank you.
That's
But
good.
I
Thank you.
really, really recommend checking out these PDFs. There's some websites on there that will help you clean up your act big time about all this planning stuff. So,
Yep.
all right.
Thank you.
I'm closing this meeting now. And
Bye-bye.
Okay. Thank you, Ann. Thank you, Lisa.
Thank you so much.
Thank
Bye,
you, everybody.
I can figure out how to do it. I can't
Want
find
me
it.
to-
Okay.
Bye, Annie.
Bye-bye, guys.